Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my private Facebook group, which is called Foreclosure Help 777. And if you'd like to join us, if you're in foreclosure, we help each other out. And if you have any questions or comments, you can always send me an email to foreclosurehelp777@gmail.com with your question, and I will try to answer that for you. Today we're going to talk about a very important subject, which is called discovery. And discovery is where a lot of people get to where they need to get in your litigation. Whether you're the plaintiff or the defendant, discovery is something you should know about and know how to use. So we're going to go over that. Let's talk about discovery. I made a little cheat sheet here to go over with you guys, some discovery tips. Timing, when discovery starts. The time to file discovery with the other side is after pleadings are closed. In most states, discovery begins after the complaint and answer, including preliminary objections or motions to dismiss, if any, are resolved. Check your local rules. Some courts require case management order or scheduling order before discovery can begin. Don't wait too long. Start drafting your requests early so you're ready to serve them as soon as discovery window opens. Discovery tools to use. Requests for production. Okay, that's where you ask them for what you want. Demand copies of the note, mortgage, allonges, assignments, servicing records, payment histories, escrow analysis, 1099s, call logs, insurance records, etc. This is what you're asking them to give you. Interrogatories are written questions forcing the plaintiff to explain things like the chain of title, who owns the note, and how the debt was calculated. Requests for admissions. Ask them to admit or deny simple but powerful facts. Admit that plaintiff does not possess the original promissory note is an admission. If they don't respond, they are deemed admitted. Depositions are another thought. Rare in pro se cases, but very powerful if you can depose a robo-signer or a servicer rep. A subpoena is useful for third parties like MERS, counter recorder, prior servicers, notaries, if you need to subpoena something. Strategy tips. Target standing early. Make them prove that they own and hold the note and mortgage. Many foreclosure plaintiffs can't. Focus on gaps and inconsistencies. Compare assignments, endorsements, and payment history to spot contradictions. Use broad language. Ask for all communications, whether electronic or paper, external or internal, about your loan. Don't accept "we don't have it." Push back if they refuse to produce. File a motion to compel if needed. Admissions are gold. Draft your RFAs carefully. If they fail to respond, you can win major points automatically. Practical tips. Keep requests reasonable. Too broad equals an objection. Too narrow is useless. Strike a balance. Number everything clearly. Each interrogatory, request for admissions, or request for production should be separate and easy to enforce. Use exhibits. If you already have questionable assignment, attach it and ask them to authenticate it. Calendar deadlines. Discovery has strict response times, usually 30 days. So track them and be ready to enforce. In other words, when you send them discovery, send it certified mail return receipt so you know when they got it. And you can mark your calendar 30 days after. Meet and confer. Courts often require you to try resolving disputes before filing a motion to compel, so document these attempts. Letters, stuff like that. Use discovery to your advantage. Build a record for trial or motions. Even if you don't win discovery battles, the paper trail shows the judge what the plaintiff refuses to produce. Support counterclaims. Use their own documents or missing documents to prove FDCPA, RESPA, TILA violations, or wrongful foreclosure. Leverage in settlement. Strong discovery responses or their failure to respond can push servicers toward loan mods or dismissals. And I don't know if I'd agree to a loan mod, though, guys. You know what I mean? Impeachment tool. If the witness testifies one way and you have contradictory discovery answers, you can discredit them. Common pitfalls to avoid. Waiting too long to serve discovery. You don't want to wait too long. You got to know when the time to do it, right? Accepting vague responses like see business records without demanding specifics. Not following up with a motion to compel. Another thing you can't do. You got to know how to do this and be really strong. Failing to keep discovery requests consistent with your defenses and counterclaims. Okay, so those are some tips about discovery. Let's take a look at what discovery looks like. We'll use Christian Curse as an example, because he has some pretty good discovery that he's going to serve. Now, he hasn't served them yet, but this is what it's going to look like. You want a cover letter to the other side's attorney, which is what this is. It's a cover letter, and it tells them, please, enclosed, please find defendant Christian Curse's first set of interrogatories, first request for production of documents, and first request for admissions directed to plaintiff, served pursuant to the Pennsylvania Rules of Civil Procedure. Now keep in mind, Christian is the defendant in this case, and he's fighting a foreclosure. It's a judicial state, so he did file answers and counterclaims, and this is what this discovery is about. And he says, pursuant to the rules, timely responses are required within 30 days of service. Kindly confirm receipt of these discovery requests. Should you have any questions, blah, 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 right? So that's that. And then you can see right here, enclosures, defendant's first set of interrogatories, production, and admissions. And then the first page should be your instructions and definitions page. And depending on what state you're in, you want to make sure that you tailor your instructions and definitions to whatever state you're in. And you can also use AI to help you do this, guys. I know a lot of you are learning about AI and how to use it. Well, use AI to help you with your instructions and definitions. Just say, I'm writing discovery and I need my instructions and definitions, and it will give them to you. And basically, this says that these interrogatories are propounded pursuant to the Pennsylvania Rule of Civil Procedure 4005. Your answers must be made separately and fully in writing under oath within 30 days after service. Each interrogatory must be answered based upon all information in your possession, custody, or control, including that of your attorneys, agents, representatives, and servicers. If you object to any interrogatory, state the specific grounds for objection and answer all parts of the interrogatory that are not objectionable. If you cannot answer an interrogatory in full, answer it to the extent possible and state the reasons why you cannot answer for the remainder. If you claim lack of knowledge, you must describe the efforts made to obtain the information. If you claim privileged, client, attorney, privilege, blah, 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 identify the nature of the information withheld, the grounds for asserting privilege, and sufficient detail to allow the court to determine whether the privilege applies. These interrogatories are continuing in nature. If at any time you obtain additional responsive information, you are required to promptly supplement your answers in accordance with the rules of civil procedure. Then we have the definitions, and these are pretty straightforward. Plaintiff refers to Deutsche Bank National Trust Company as trustee for Soundview Home Loan Trust 2006 OPT1, its predecessors, successors, affiliates, trustees, custodians, agents, attorneys, and servicers, including PHH Mortgage Corporation. That's the plaintiff, guys. The defendant refers to Christian Curse, the named defendant in this action, loan or mortgage loan. And see, these are just definitions, guys. I'm not going to go through every one of them, but they should be in there when you serve them with discovery anyways. It's just proper. And then identity, servicer, assignment, you or your. Okay, now then we get to the good part. Defendant's first set of interrogatories. And basically, like the first question says, identify all persons with knowledge of the alleged loan, assignment, servicing, and foreclosure proceedings, including their role and contact information. State whether plaintiff or PHH Mortgage is currently in possession of the original wet ink promissory note. If so, identify where it is located and who has custody. State the complete chain of assignments, transfers, or endorsements of the note and mortgage from origination, which was option 1, through present, including dates and parties involved. Explain the basis upon which plaintiff contends it has standing to enforce the mortgage loan. Identify all communications between plaintiff, PHH, and Sand Canyon Corporation regarding the subject loan after 2008. Identify all notices sent to defendant under Act 91 or Act 6, including dates, methods, or mailings, and parties who prepared and sent them. Identify whether the Soundview Home Loan Trust it was an active entity in 2011, and provide plaintiff basis for asserting that the trust could accept the 2011 assignment. Okay, now these are tailored to his situation, guys. You want to tailor your questions to your specific situation. So we won't go through each one of them, but I just wanted you to get an idea of what his interrogatories look like. And you can see that they're pretty specific questions. Number 12, identify all attorneys, law firms, or foreclosure mills retained in connection with the subject loan, including dates of retention and scope of authority. So we are getting to some really detailed questions that they have to answer. And of course they don't want to answer half of these, you know that, right? But the point is to get them out there, so that way if they don't answer them, we can compel them to answer them. Next section is request for production of documents. And again, we have instructions and definitions, just like before. Same thing. You want to do this for each thing. Request for production. And again, these are things you're asking them to give you. Produce the original promissory note for inspection, along with all allonges, endorsements, and riders. Produce all assignments of the mortgage, including the October 11, 2011 assignment from Sand Canyon. Produce all trust documents, the pooling and servicing agreement, prospective supplement, and other governing instruments for Soundview Home Loan Trust. So again, these are things you're going to ask them for, and we won't get to every single question, but you get the idea of what you want them to produce. Produce all monthly mortgage statements or billing notices sent to defendant from origination through present. Produce the complete servicing file for the defendant's loan, including all electronically stored data, ESI, call notes, servicing records, payment applications, suspense account records, and transaction histories. Now, that's something I got when I was fighting Bank of America. They sent me a CD-ROM that had all that on there. And that was their nail on the coffin move, because as soon as I got all that, everything changed. And, you know, I stayed in my house almost 10 years after I got all my servicing records. Okay, so you get the idea of what you want them to give to you, all these things. That will help your case. All right, so we have 30 things that we're asking them for. And then the last section is, of course, admissions, which I think are my favorite. Again, we have definitions and instructions, and then we have, you know, you want them to admit these things. Admit that plaintiff does not currently possess the original wedding promissory note. Admit that Sand Canyon Corporation ceased originating or holding mortgages by 2008. Admit that the Soundview Home Loan Trust filed a Form 15 with the SEC on or about January 17, 2007. Admit that the Soundview Home Loan Trust ceased acquiring new mortgage assets after January 17, 2007. So they have to admit to these things. And getting them to admit to these is gold. Because if they have to admit to this, then you can file your motion for summary judgment later and explain that they've admitted to all these things. Okay, and so the rest of these admissions are pretty straightforward. Again, your situation is probably different, but you want to get them to admit everything that you want them to get to admit to so that you win your case. Okay, and he's attacking standing. They don't have the note. They didn't attach the note to the actual foreclosure complaint. Then you have to do a certificate of service and sign it. And that's pretty much it for the discovery package that you'll send to them. I hope this was informational to a lot of y'all. I know a lot of y'all are new to the foreclosure fight and don't know really what to do or where to begin, but hopefully this will be helpful. And thank you for subscribing, and hope everyone has a blessed day.